Good morning, KSLU law students. Welcome to today's Explainer. I'm your professor, and today we are focusing strictly on securing maximum marks for the contract of guarantee questions under the Indian Contract Act of 1872. Listen, we are going to tolerate absolutely no vague answers today. This session is a rigorous, explicit breakdown of the rights of a surety and the modes of discharge. If you want a 16 out of 16 on your final exam script, you need to pay close attention. Take out your notebooks right now and prepare to absorb the precise statutory structure that the university evaluators actually demand. All right, let's dive straight into this.
Our agenda today: 1. Introduction. 2. Rights against principal debtor. 3. Rights against creditor. 4. Rights against co-sureties. 5. Modes of discharge. And 6. Conclusion. You need to treat this exact sequence as the structural blueprint your KSLU examiner expects to see. Do not skip this step.
Section 1. Introduction to Guarantee. Let's establish our foundational landscape here. Three parties: surety, principal debtor, and creditor. Surety undertakes secondary liability. Law provides rights, protections, and discharge circumstances. Okay, let's dissect this immediately. A contract of guarantee is not some simple bilateral agreement, right? It's a tripartite mechanism. The dynamic here is absolutely critical. The surety's liability is secondary. What does that mean? It means the principal debtor is primarily liable to pay, but if he defaults, that's exactly when the surety's liability crystallizes. Because the surety is taking on another person's financial burden, the Indian Contract Act essentially throws a strict protective ring around them. The statute provides undeniable rights and very specific circumstances under which the surety is completely discharged. You absolutely must emphasize this secondary nature in your introduction.
Rights of surety, rights against principal debtor. Now, when you write this in your exam, I want you to use a bold pen and double underline your primary heading. Here is the law. Right of Subrogation, Section 140. After paying debt, surety steps into shoes of creditor, exercises all rights. Versus right to indemnity, Section 145. Surety entitled to recover all lawful payments made from principal debtor. So what's really interesting about this conceptual difference is how it practically operates. Under Section 140, stepping into the shoes literally means the surety inherits the creditor's exact legal position. Every mortgage, every single pledge, every right the creditor had against the debtor, that now legally belongs to the surety. Conversely, Section 145, the right to indemnity, well, that's a financial recovery mechanism. It means the surety is legally entitled to claw back every single rupee of lawful payment he made on behalf of the debtor. You must quote the exact section numbers, 140 and 145, to score full marks here.
Next subheading: Rights against creditor. Maintain this exact sequence for logical flow on the exam. Right to securities, Section 141. Benefit of all securities held by creditor. If lost, surety discharge to that extent. Right to set off. Right to request creditor to sue debtor. Let's pause here and deeply explain Section 141. The absolute crucial point is that a surety is entitled to the benefit of every single security the creditor has against the principal debtor at the exact time the contract of guarantee is entered into. Think about it. If the creditor carelessly loses a security or parts with it without the surety's explicit consent, the surety is severely prejudiced. Therefore, the law strictly dictates that the surety is discharged to the exact financial extent of the value of the security lost.
State of Madhya Pradesh v. Kaluram. Students, you must write this case law in a separate, clearly drawn boxed format on your exam script. Do this to immediately capture the KSLU evaluator's attention for your 16-mark answer. Let's break down exactly what you need to write. Here are the brief facts. The state sold felled timber to a buyer, who was supposed to pay in installments. Kaluram stood as the surety. The contract clearly stated that if the installments were unpaid, the state could legally stop the removal of the timber. However, the state negligently allowed the buyer to remove the timber without actually receiving the payment. So, what was the final ratio decidendi of the Supreme Court? It was absolutely clear. The state lost the security, which was the timber, due to its own negligence. Therefore, the surety, Kaluram, was completely discharged from his liability. The absolute relevance of this case to Section 141 is that it concretizes the rule. A creditor's carelessness with securities directly and proportionally cancels the surety's obligation. Write it exactly like that on your paper.
Moving to our final category of rights: rights against co-sureties. Now, this is exactly where evaluators looked for specific distinctions in liability. Right to contribution, Section 146. Co-sureties share liability equally. Right in case of different liabilities, Section 147. Contribution is proportionate to agreed liability. Let me explain the strict mathematical difference in KSLU application here. Under Section 146, if 3 co-sureties guarantee a debt and there's no contrary contract in place, they bear the burden equally. Say the default is 30,000 rupees, they pay 10,000 each. Simple, right? However, Section 147 kicks in when sureties agree to distinct, separate financial limits. In that scenario, the contribution is proportionate to their maximum agreed liability. They basically share the burden mathematically, but only up to the limit of their respective guarantees. State these sections very clearly.
Heading I, Modes of Discharge of Surety. When you reach this part of the exam, I want you to start a fresh page in your answer booklet for clean presentation. 1. By revocation. Revocation of continuing guarantee, Section 130, by notice for future transactions. By death of surety, Section 131, discharges liability for future transactions. Let's elaborate fully on this. Notice the critical phrase, future transactions, appearing twice here. A continuing guarantee extends to a whole series of transactions. If a surety gives a notice of revocation, or, unfortunately, if the surety dies, the guarantee stops right there. But it only stops for the future. The past liabilities, those transactions that occurred before the notice or before the death, they remain perfectly intact. The surety's estate remains fully liable for those past debts.
2. By conduct of parties. Variance in terms, Section 133. Any change in contract without surety's consent leads to discharge. Release of principal debtor, Section 134. If debtor is released, surety is discharged. I need you to emphatically note this. The surety's consent is the absolute anchor of the contract of guarantee. If the creditor and debtor sit in a room and change the terms of the agreement without asking the surety, the law under Section 133 immediately discharges the surety. No questions asked. Furthermore, under Section 134, if the creditor legally releases the principal debtor, the secondary liability of the surety vanishes instantaneously.
Holme v. Brunskill. Instruct your pen to underline this case name heavily to capture attention. Here is the deep breakdown you are going to write. The facts. The defendant stood surety for a farmer's lease of a farm that included a flock of 700 sheep. Later on, the landlord and the farmer agreed that the farmer would surrender one field, and in return the rent would be reduced by £10. Crucially, they did this without informing the surety. The ratio decidendi here? Even though the alteration seemed beneficial, or honestly at least not harmful to the surety, the court held the surety was discharged. Why? The absolute relevance to Section 133 is this strict legal principle. A surety is only bound to the exact letter of his specific engagement. Any unconsented variance, big or small, materially alters the risk profile he originally agreed to. Write this down clearly, and you will secure those marks.
Notice this sequential progression for an arrangement with debtor under Section 135. Creditor gives time or composition, then surety did not consent, therefore surety is discharged. Why exactly does this sequential progression exist? Well, if the creditor independently grants the debtor an extension of time to pay, or enters into a composition, which just means settling for a lesser amount, without the surety's consent, the surety is severely prejudiced. You see, the surety might have actually wanted to pay the debt immediately upon default, and then immediately sue the debtor while the debtor still had some liquid assets left. By giving the debtor extra time completely behind the surety's back, the creditor handcuffs the surety. And that acts as an absolute legal discharge.
Other discharge modes include 3. By impairment of surety's remedy, Section 139, 4. By loss of security, Section 141, and 5. By invalidation of contract if it's void or illegal. Section 139, by the way, is a beautiful blanket protection. If the creditor does literally any act which is inconsistent with the rights of the surety or omits to do any act which his duty requires him to do, and this eventually prejudices the surety's ultimate remedies against the debtor, the surety walks free. This, alongside the loss of security and the underlying contract being rendered void, forms the complete defensive shield for the surety.
Section 6. Conclusion.
Every 16-mark answer must end with a definitive conclusion. The law of guaranteed balances the liability of surety with adequate rights and safeguards, preventing injustice. This brilliantly illustrates how you should perfectly cap off your answer script. While the surety undertakes a massive financial responsibility for another person's debt, the Indian Contract Act explicitly prevents exploitation. Through powerful rights like subrogation and indemnity and very strict discharge modes regarding unconsented variances, the statute absolutely ensures fairness. Now, I will leave you with this final, provocative academic thought for your own legal careers. As you enter the profession, ask yourself, whether modern banking practices, with their dense, multi-page standard form guarantee contracts, actually respect these statutory safeguards, or do they attempt to completely contract out of the very protections Sections 133 and 141 were designed to provide? Ponder that. Study hard, structure your answers exactly as we discussed today, and go secure those marks. Class dismissed.